Hello, and welcome to Post-Pandemic Legal Liabilities for Employers. My name is John Accorsi. I'm a Senior Account and Product Manager at M. Holland Company, and this year's President of the Wire Association New England Chapter. Jonathan Roof and I will be your moderators today. Today's sessions are being recorded. Connection details will be forwarded after the presentation. And now I would like to turn the session over to Jonathan Roof to talk about the New England Chapter Education Committee and to introduce today's speaker. Jonathan?
Hi, everyone. Thank you for attending today's event. My name is Jonathan Roof with Rainbow Rubber and Plastics, and I'm a co-chair with Lori Parent of the New England Chapter Education Committee. Part of the Education Committee, we try and create events for the membership to better understand parallel or complementary processes within the wire and cable industry and to encourage networking. Typically, the events are hosted on site by companies such as Davis Standard or Techner Apex, which included plant tours to showcase their production and different capabilities. We're always looking for new opportunities, so if any of today's attendees have ideas or would like to host an event at their facility, please feel free to reach out to either me or the Wire Association after this event. With COVID limiting our ability to meet in person and not wanting to miss out on an opportunity, Lori enlisted the help of Katherine so she can shed some light on legal liabilities and the new normal for employers during a pandemic. Now I'd like to introduce our presenter, Katherine Witherspoon Fry. Katherine is an employment law partner at the law firm of Offit Kerman. She has 26 years of experience in employment law as a litigator, advisor, and mediator. Katherine advises clients and litigates cases nationwide and has made 2 appearances before the U.S. Supreme Court. She also teaches HR law as an adjunct professor at the University of Delaware and is a Delaware Supreme Court appointed hearing officer and certified mediator. Katherine is a graduate of Duke University and New York University School of Law. So without further ado, I will hand it over to Katherine and she can better educate us. Thanks, Katherine.
I wonder if we're tired of hearing about this. I know I'm tired of hearing about this. I'm tired of talking about this. We, however, have to talk about it and we have to keep dealing with it. At COVID-19, it's everywhere. It's all the time. It's no fun, but it is what it is. And so, you know, as a lawyer, I've been doing a ton of work beginning in March 2020 on this subject. It's sort of pick up the phone and ask Katherine whatever comes up that's really strange in your workplace regarding coronavirus. So I have a lot of familiarity with it. And, you know, I try to look at this as a new normal. For now, we're still in a new normal, and we have to talk about how we manage our legal risks of dealing with the new normal. We do have to, you know, keep at it. The one thing I would say to you is that we do need to stay in place. We need to make sure that nothing is let go at this point. We can't slack off is what I'm trying to say. I know we have COVID fatigue, and that's what I sort of led with. We do have COVID fatigue, but let's talk about this stuff today. And I think you'll understand why it's very important not to let it go. So today I'm going to talk about legal liabilities for employers, what's going on right now, what I've seen, what I predict, policies that every business should have to reduce its liability, why and who to vaccinate, recommendations about what should happen with regard to vaccination and after your workforce is vaccinated, best practices for returning to work after your illness or exposure, and paying your sick or quarantining workforce without killing the bottom line, I like to say. So this does say preparing for the avalanche of new claims. However, we've started seeing some new claims already, unfortunately. These can include all of the following bullet points, which I hate to break it to you, but it's a long list, right? So the first one is OSHA. OSHA is about to issue new regulations. I'm very, very excited about this because I'm an employment law geek. I'm very excited about them getting regulations. And the reason you should be excited too, as a business owner or business person, is that we will finally have definitive regulations with guidance. And we've been begging for this since March. So a few states have issued regulations, but most have not. I deal with some Virginia employers and they have regulations, and they can be burdensome, but at least they know if they're doing certain things, they're not going to be in trouble. They're not going to get sued by their employees or their customers, et cetera, because their defense is, we followed the regulations and that's it. New Jersey is the same. New Jersey has regulations. So there is at least a little satisfaction, and well, I cannot be nailed because I follow the regulations. That's my complete defense. So now we'll have OSHA regulations, and that is really, really going to help matters a vast deal. I'm very happy about that. It was given to the White House. It's in the Oval Office as of last week. And usually these things take about 2 weeks to come out. So look in 2 weeks, a week and a half from now, look for those regulations. It's going to be all over the news. And then, my advice is going to be follow those regulations. I'll get into that, but absolutely adhere to the regulations. Don't forget about your state executive orders, your emergency orders, whatever your state calls it. Because, interestingly, the state might be stricter than what OSHA says. We have different variations going on, and you have to make sure the state doesn't nail you, nor does, any federal agency like OSHA come down on you. So we're going to have more new claims in the workers' comp field, and that's going to be, of course, because people are alleging that they got COVID-19 at work. Now, I was alarmed recently to discover that some nationwide major insurance companies are denying these claims. They're saying, no, this isn't workers' comp because there was no anticipated exposure at work to COVID. This is not a known thing that might happen. For instance, this is not a truck driver having an accident. This is, well, you can get it anywhere, so it's not work related. This is bad news for employers because we as employment counsel, I've been doing this 26 years, we're thinking that was not going to be the case. We were thinking that workers' comp was going to preclude people from suing directly their employers for personal injury and pain and suffering, et cetera, loss of consortium. In fact, when I found out that Walmart was being sued for wrongful death, I thought, that's probably going to be covered by workers' comp, right? But unfortunately, not only are some courts perhaps going to preclude workers' comp in cases of willful, crazy type decision making, something that nobody on this call probably would ever do at this meeting would ever do. That's going to be precluded from workers' comp coverage. Which was alarming to me is that the insurance companies are saying, no, we have nothing to do with that. We're not going to do it. Am I surprised? Maybe not, but that is what's going on, unfortunately. So then that covers the next bullet point. I've talked about negligence and for personal injury or wrongful death. Those are going to continue to be prevalent. Those are ongoing. People have sued, they're working on the cruise ships and they've sued them. Amazon, Walmart, a lot of major retailers, and it's all alleging that, they knew that things needed to be, locked down, way more protected, way more PPE, and they just failed to do it. They just didn't do it in the face of, crisis. So, and then you can understand the cruise ship thing. I mean, everyone knows about the cruise ships and why the employees would be complaining about that, right? You got people on here, you knew they had COVID. What were you doing, right? That kind of thing. You found out that people had it. You didn't insist that everybody go to their rooms immediately. That stuff is kind of a horror story. And hopefully didn't go on in a lot of places. So we'll see about that. We've got Americans with Disabilities Act. It's going to be a problem because more people are going to have issues with their disabilities given that there are underlying medical conditions which can be sorely affected by COVID-19, as we know. Americans with disabilities also comes into play when people are working at home. And then they say, well, this is a reasonable accommodation for my disability. I am unable to go in because of my medical condition and I could be exposed and so forth. What do you do with that? It also comes into play with vaccines, and I will talk about that in a little bit. Family Medical Leave Act is, of course, the thing that is right now in place for people who have 50 employees or more within a 75-mile radius. It's 1,250 hours. If the employee has worked for 1,250 hours the preceding year, then in each 12-month period, they have 12 weeks of unpaid leave. Okay, so this may well apply because we've got our people who are caring for their own serious illness, which could be COVID or things related to COVID, right? And caring for others. And those things are encompassed by the Family Medical Leave Act. The problem with that is that people are going to be denied those leaves. That's going to happen, especially right now. We've got worker shortages, and maybe some employers are very reluctant to let people do that. Sometimes employers think people are making them up. Sometimes they are making up their needs, and sometimes people can get a doctor to sign off on something that is based just on what they've told the doctor. I've seen this many times, and the doctor writes a note that says, patient reports that she has had XYZ. So I'm saying that she needs to be off of work for 3 weeks. But the doctor doesn't have the evidence. The patient is presenting it. So those issues are definitely going to come up. And how does that interact with the sick leave that we've had in place for the pandemic? There are new medical leave acts, paid medical leave acts pending in a lot of states and also in Congress. So we need to look out for that and see what happens with that. Those are a lot more generous. They're paid leave versus FMLA, which is unpaid. And again, just so much is happening right now that has come up to the forefront again because of COVID-19 and people saying, well, wait a minute, if you work for a company of over 500, your employer was not even compelled or forced to give you any paid sick leave. Congress left them out, right? So if you had from 0 to 499 employees, you had to give people sick leave. You had 2 weeks of paid sick leave and that family leave to watch their children who were not in school or in daycare of up to 12 weeks. But guess what? If you were at a company of 500 or more, you didn't have those protections. So you were falling back on FMLA. And state law, sometimes some states have paid sick leave. I believe it's 9 right now have paid sick leave, and it's pending in many, many states. But anyway, that's all come to the forefront because of this crisis. We're going to have to look at wage and hour problems, timekeeping at home. How do you do that? Do you have to pay people for the time they spend getting tested because you told them to get tested? Do you have to pay people for time getting vaccinated because you told them to get vaccinated? What's compensable? That means, do you have to pay them for it? And then do the duties change somehow from exempt to non-exempt because of shifting work duties, work roles? I have a lot of restaurant clients, and they have had issues with managers having to fill in for people, especially when they're calling out all the time because of COVID exposures and so forth. So the managers will have to fill in, and you just have to look and make sure that your managers are not spending most of their time now doing non-exempt tasks, in which case you have to shift their role. So keep that in mind when you're changing people's duties, that they might be changing to a non-exempt and you do need to pay them overtime. The timekeeping is interesting. There's technology now that can, you log in anywhere and so forth. But then my clients say, but how can you tell if they're working or not? How do you know? They log in and they clock in and what have you, and they clock out at lunchtime and stuff. But how do you know they're doing anything? I say, well, number one, what's their productivity, right? Are they getting things done? Are they not getting things done, right? And then second, are you interested in installing the software that measures keystrokes, because there is such software. You can tell if the person's actually typing on their computer or doing anything on their computer. But honestly, the whole work at home thing is much more about motivated people and helping them feel safe so that they want to work at home. They really want to work, but they want to do it at home. They feel safe. That's good for them. That's good for morale. We want to make sure that people, are not getting sick. So of course, that's a good reason. But at the same time, you should have a really good written working at home policy, a teleworking policy. A lot of companies didn't have this before this happened, but now I'm writing a lot of these. And, part of that policy is like, look, if you're not doing what you need to do at home, you have to come in. I mean, there's nothing like that. And there's nothing like, a reminder of that policy to motivate people to get their act together, as far as my experience has shown. They don't want to come in. So, oh boy, I better pick it up, right? So, but that can be an issue that's come up, has come up for my clients. We have unemployment comp issues. The latest, greatest is that people are stealing other people's identities, including their social security numbers, and filing for unemployment in their name. So you'll get this notice that you have, your claim has been processed, or, thank you for submitting your claim, or what have you. And the reaction is not good. The reaction is really not good. So what do you mean? Oh no, somebody is right. And then they need to take steps. Those people need to take steps to make sure that, they've notified the police, that they've done all the things they should do to protect their identity. It's really not good. So people just have, broken into databases, stolen people's names and socials, and, where they live. And so they can apply to the appropriate state office for unemployment. We've also had, I've seen this a lot too, unemployment comp issues regarding people who wanted to collect unemployment and not go to work. It was safer for them to stay at home. Why not sit home and get the extra $600 a week? Hey, if you weren't making $15 an hour for a 40-hour week in the first place, then sitting and taking $600 alone, much less the regular state rate, even the additional comp was more than you were making before, right? So we're having sort of a crisis with that. That's one reason I see my clients have lost workforce. There are a lot of other reasons now, we know that, people staying at home to watch their children and so forth and so on. But unemployment has been a really big deal for my clients, and it's just, I don't see any end in sight to that. We have to get vaccinated. I guess we have to get herd immunity, at what everyone else is saying. I'm not a health expert, but unfortunately I play one on TV or at my desk all day long when people are asking me these things. Unemployment comp has been a real problem because it also now goes on 26 weeks. People don't seem to understand, that is, employees don't seem to understand, some employers don't either, that if you offer them the job, again, if you say, okay, you're off furlough, hey, I'm able to bring people back, please come back to your job, that they're no longer qualified for unemployment. They can't get unemployment anymore if they turn down the job they originally had, or any suitable job, right? So they're actually committing unemployment insurance fraud. So, maybe that's helpful to you. Maybe you can point that out to a few people. I certainly find it compelling. So, like, well, look, remember, you can't get unemployment, and you as an employer can contest it. You can say, I don't like this account, my account being put in this possession. I think that most states are not counting this kind of stuff against people's unemployment accounts, employers' accounts. But, and maybe it's just the principle of the thing too. These are your tax dollars paying this, and, maybe you want to report it. But I think definitely tell the employee, by the way, if you don't accept this, that it's unemployment insurance fraud to keep collecting. I just think that's a smart thing to do. You don't want to be pulled into as someone who's colluding with them, right? So that's not a good idea. We're going to have a lot of discrimination claims, are already seeing a lot of discrimination claims because I defend them for companies, about who was laid off, right? Who was laid off, who was furloughed, and this group was, and this group wasn't. And then we've got the whole, You bonused this group, but you didn't bonus that group. You gave these people hazard pay and you didn't give those people hazard pay. There are a lot of things that seem on their surface to be, non-discriminatory. Hey, I'm going to give all the field workers a bonus because I feel like they've been out there exposing themselves, seeing the public, etc. And then I'm not going to bonus my people behind the scenes, my office people. They really haven't been doing that. So I had a client ask me about this, and I said, well, just let's keep in mind that's a neutral policy, but we don't want to create a disparate impact on one group with a neutral policy. Just let me know. Are the field guys, are the field people guys, are the office people women? Okay, do you see the problem? And he said, oh, okay, yeah, I get it. The CFO said, yeah, no, yeah, I see. And so I think they decided to bonus everybody, which was very generous and not necessary, but you just have to think about disparate impact a little bit when you're thinking about a policy that seems perfectly neutral. As applied, then it can have a disparate impact and be actually discriminatory. So, and then last we have whistleblower claims. And of course, retaliation for reporting the company to OSHA, reporting the company to other health authorities, reporting the company to the state for health violations. All of that has taken a tick up. And I should say, I didn't mention with discrimination claims, that includes I'm just going back for a second, that includes retaliation claims, right? Not just whistleblower retaliation, but regular retaliation. You reported, for instance, that someone with you reported yourself, say, that you have a disability and you needed accommodation. Then you were refused that and you got laid off. There you go. There's your retaliation claim. Not saying, any of these are valid. I'm saying that employers have to look out for them because you're going to have to defend them. You're going to have to hire someone like me who will suck you dry. Just kidding. And you'll have to defend them, which is not what you want. So just keep eyes open. So in order to avoid some of this, we are recommending that people update their current policies for sure. So of course, sanitization and distancing, check the CDC. That has been the Bible, really, the guidance from the CDC for businesses and for medical practices, depending on my client. It's check the CDC. If you don't check the CDC, call me. I will have checked the CDC and I will let you know what it is. Here we go, though. We're getting OSHA. We're getting OSHA regs. Very hopeful about that within the next week and a half. So that's going to be great. OSHA did have guidelines, but there was nothing regulating anything. So that was the problem. However, I've been advising people to check OSHA guidelines because there's a general duty to provide a safe and healthy workplace, as everyone knows. And there are guidelines on OSHA. The CDC and OSHA have guidelines. And then, of course, there's state guidelines. So make sure your policies, your written policies are compliant with those. Super important. Sick leave updates. You're going to want to, decide what your approach is. Are you going to give paid sick leave? Are you not going to give paid sick leave? Can talk a little bit later about the paid sick leave and how you can pay for it yourself without having to dip into your own pockets. Probably a lot of people know about that, but I want to make sure that's covered. But hey, has this made you think about it a little more? Do you want to give people more sick leave after they've exhausted what you thought was reasonable? Make sure you update your policies on that. Maybe you want to give unpaid sick leave. That's something that's always an option. For a limited period of time, just do unpaid sick leaves. You can always change the policy later. And, every policy manual that I write for COVID-19 says this policy is, subject to revision at any time. This is an evolving situation. As things change, this will be updated. And so I write an addendum to people's handbooks. And the addendum is this policy that I'm kind of addressing here. Although, some of this goes back to your main handbook too, just because of a changing atmosphere. You can provide for employee leaves of absence. That's a new thing people are thinking more about, again, just because they might need, time to recover from something, long haul COVID, for instance. Or, someone in their family got really, really sick and they need to care for them. and you don't have 50 employees, so they don't have FMLA. As I said, you want a formal teleworking policy. Number one on the policy is this is a privilege, not a right, right? And part of that should cover home office safety. Unfortunately, workers' comp can find compensable events when someone is working at home. So a safety checklist is a great idea. You have everyone gets the safety checklist. Insurance companies could give you one, probably. I could give you one. Feel free to contact me after the presentation and I will give you one. And basically it's, fire hazards, tripping hazards, electrical hazards. They have to check their home workspace and see if they're going to perhaps incur injury. So crazy case, woman is getting coffee break, going for a coffee break and trips over her dog. And that state's board found that to be a compensable injury. That's workers' comp. So, it's important. It's important. You're still liable, unfortunately, when they're at home, even though, because they're your employee, right? So testing policies, when are you going to require a test? Are you ever going to require a test? Self-reporting symptoms, a must, right? Everyone's probably doing that by now, but there are different methodologies and you should specify how you want that done. Policies about their returning to office after they're exposed. I'm going to talk about that a little bit later too. Travel policies, vaccinations, which should cover your exemptions from vaccination. If you're mandating it, you should provide the exemptions and explain about that, which I'll talk about too. You might want to have vaccination incentives. You might want to explain why you're strongly encouraging the vaccine, but all of this stuff would be great to put in writing. And so there's no question in anybody's minds, right? And don't forget, whenever you have written policies, you need to have your people sign off. They need to sign acknowledging that they received the policies, that they reviewed them, that if they have any questions, they should come to management. That's very important. Employee classification, again, we talked about that a little bit. And then, any state specific provisions that you're going to need to put in pursuant to state law, think about updating your policy on those things too. So, we need to practice OSHA and CDC workplace guidelines. So this is my point. OSHA has been roundly criticized for not promulgating federal safety regulations. And I wrote this last week before I got the news that OSHA was finally supposedly doing this. And it still hasn't been done. So meantime, look at the guidelines. There are probably more investigations coming. They have done, again, an uptick because people were actually saying, what's wrong with you people? You're OSHA. Why aren't you investigating these workplaces? And so there wasn't the uptick that they expected given this pandemic. And so people have come down on OSHA and they've been doing more investigations. So just be aware of that. They are investigating. As I said, some states do have their own regulations and be sure to check them. Some of them you have to have a written COVID policy. For instance, New Jersey, you have to take each position and evaluate the risk for each position, whether it's low, medium, or high risk. That's Virginia, and then decide what you're going to do with each employee in those categories. It's a lot. So so do we vaccinate or don't we vaccinate? And it's to vaccinate or not to vaccinate. I've stolen from Shakespeare, right? It's to be or not to be. That's Hamlet. And what Hamlet is talking about is whether he should commit suicide, to be, to exist, or not to be. So, looking at vaccinations, it's should we do this to be? Should we exist? Should we be alive or not to be? Vaccination, right? Don't vaccinate. This is what might happen. But, according to a recent survey of 1,800 people in the know, in-house lawyers, HR people, et cetera, less than 1% of companies are requiring COVID vaccinations for everybody. 6% are saying, well, we'll gear up when there are more vaccines available. This data is a few weeks old. So, it just in a few weeks, we've really ramped up. So maybe at this point, we're seeing more like 7% of employers are saying, yes, they're available, we're mandating them. People are still looking at this decision. Maybe your company is still looking at this decision. But most of my clients are strongly encouraging and not mandating the vaccine. It's just a lot to go through and exempt people who need to be exempted for various reasons. And that's part of the reason why they're not doing it. Also, they may not be that type of workplace where the risk is higher of transmitting it from employee to employee or to customers or clients. Determining, what to do is largely driven by the nature of the employer's business and maybe by what they're doing. So the ones that I'm seeing are my medical practices, medical care kind of stuff. Those are the ones who are really insisting and mandating, which does make sense to me. I have one client that has only vulnerable patients, only medically vulnerable patients. They're all being treated for a serious condition before they step foot in that office. So, they felt very strongly, we want to mandate this. So we have to talk about how you can do that legally, and also whether you should do that at all. So there's some more considerations. How close are they? How much exposure do they have to the public? How many vulnerable people are present? Like I was just talking about in the medical office. Big one. How gigantic of a PR nightmare will it be to have a large outbreak? And then you hit the news and the entire factory shut down and so forth. And this segues into the next bullet point, which is how likely is the business to be closed if there is an outbreak? How serious are your state regulators? How likely is it if a few people get it that a lot of people are going to get it? These are all really good considerations for whether to strongly encourage or mandate. Of course, you can always decide we're not going to take a position on this. We're just not going to speak on it. And that's fine too. That's fine. I am doing it I am telling people to do it, to strongly encourage it, because I think that the sooner that they do that, the sooner we'll be back to the old normal, not the new normal, post COVID, and people can go back to business as usual. The faster they do that, the faster we'll all be back there. Say the health authorities. Again, not a doctor, not the CDC, just listening to them. So the EEOC says that employers can create a mandatory vaccine policy if the vaccine is available, which it is becoming more widely available now. If the employee refuses to do so without a legitimate disability or religious accommodation, I'll talk about that in a minute, then they can keep the employee out of the workplace. They can fire them, they can make them work remotely indefinitely, but you can just let them go if you don't want them to work indefinitely at home, or if they cannot do their job that way. Again, the vaccine has to be truly available, accessible, the cost is free. So I think that's not an argument against it. Other considerations might be, what category are they in? Are they too young? Has the state not reached their age group level yet? That kind of thing. But I would do a formal vaccination policy, something written down. This is what we believe. This is what we're encouraging. This is how we're incentivizing it if you are, and get that out to everybody. So the exceptions for mandating vaccines, and this plays into a more common situation where employers don't necessarily want to mandate that people get it, but they're talking to people. They would like to know if they got it, right? That's very common. So client emailed us the other day and said, hey, I want to know if people got it or not and what their plans are, if they're going to get it. And he said, can I ask them that? And the answer is, you can ask them that. You can ask if they've gotten the vaccine. You can ask if they plan to get the vaccine. If you're careful to cut off the conversation at that point, don't ask them more questions. Why aren't you getting the vaccine? Don't say anything that might get them to volunteer that they have a disability, an underlying medical condition. If you don't know about it, then there cannot be a claim against the company that they knew and that they discriminated against someone based on their disability. Their underlying medical condition might be an ADA disability. So be very careful about the questions you ask. And then that flows into the disability issue here. For instance, so if you have a disability, there can be an exemption from getting this vaccine if it would be a really dangerous situation for the person with the disability. For instance, they have an allergy to PEG. This happened to one of my clients. The person claimed they had an allergy to PEG, which is an ingredient in Moderna and Pfizer. They have a doctor's written medical opinion for whatever reason that they have a condition and they shouldn't be vaccinating. And the second reason is that they have a sincerely held religious belief. Question, what is a sincerely held belief? I'm telling clients that that means people who are, dedicated to this. It's not an anti-vaxxer. It's not someone who, doesn't think that this is a safe vaccine. It's someone who, for instance, is a Jehovah's Witness and they've never been vaccinated. It's tricky though. You cannot demand a minister or a pastor or a rabbi statement. You can ask for a third party to verify that the person has this religious belief if you really want to go that far. I don't advise it. I really don't, unless you're hell-bent on mandating and the person cannot work at home. Because then you get into, oh, well, you discriminated against me later because you found out that I'm a Jehovah's Witness, right? Or because you found out that I'm whatever it is, whatever religion I am. Interestingly, I heard about this. Some Catholic people are objecting to vaccines on the basis that they were Johnson & Johnson, at least, Johnson & Johnson was developed with the use of fetal tissue from an aborted fetus. And some of the archbishops have come out and said, that's not acceptable. You shouldn't be taking that vaccine. So that would be another religious reason not to take that vaccine. So under the ADA, we do have a mandate that somebody with a disability can't pose a direct threat to the health or safety of the individuals in the workplace. So that means that if they are going to, and there's no way around it, then you could still let them go, actually. It's a very high standard though, but it is possible. I recommend very, very seriously consulting with an employment attorney before you decide to do that. It's just tricky. It's full of fun tricks. Assessment of direct threat should happen. You need to look at an individualized assessment of the 4 factors regarding COVID. And guess what? This is going to weigh heavily in favor of the risk of the person bringing in COVID because they're not vaccinated. The duration of the risk, this has gone on a long time. We don't really see an end too quickly in sight. The nature and severity of the potential harm, hey, that's really high. People are dying from it. The likelihood that potential harm will occur, that's quite likely as well because it's highly contagious. And the imminence of the potential harm, absolutely, because it's a pandemic, right? So again, you could, if you can't reduce the threat to something you find acceptable, then you can exclude them and you can actually let them go. But for accommodations, this goes like any other ADA accommodation. You have to engage in a flexible, interactive process to find out if there's an accommodation that can be made. Does this person really have a disability pursuant to the ADA? Because those are the ones that count. Not any other disability is going to hack it. For some reason, if someone said, well, I have a broken wrist and I can't get the vaccine, all right, that's not an ADA disability and that's not going to exempt them at all. But be careful about engaging in a flexible, interactive process. Find out other accommodations which could be made. If could reduce the capacity if you need to. You can cut their pay for a while if they're agreeing to that, if they're willing and everything is talked out. Reduced hours, unpaid leave until the condition subsides, if that's possible. Have them sort of isolate in the office if they have to come into the office to do their work. but make sure you document the efforts to find some kind of accommodation and some common ground, and the reasons why you couldn't, if so, and how that would cause you an undue hardship as a business. So the last bullet on here is avoid a trip to the Supreme Court. And that's to say that in 2019, my client ended up in the Supreme Court. We had won at trial and we won the motion for a new trial. There was no new trial granted. And then we won at the Third Circuit Court of Appeals and upheld the jury's decision. And then the other side appealed to the Supreme Court. So literally over a failure to accommodate claim, we went to the Supreme Court. It was hundreds of thousands of dollars of attorney's fees, which are all awardable to plaintiff, by the way. So you're paying your own, the company's attorney's fees and the plaintiff's attorney's fees in any case under the ADA or Title VII, Age Discrimination Act. There are a number of them that this happened. So, but this was literally because a person in HR, this was back when I represented plaintiffs. So that was my last plaintiff's case, I believe. But now I don't do any plaintiff's work. I only represent employers, but it's a very valuable experience being a plaintiff's counsel, because I was then able to, use that knowledge in my future work. But so 2019, though, I'm representing this plaintiff and she asked for accommodation, and HR writes a smoking gun email that says, we don't need to accommodate you. Don't know what you're talking about. Just go back to work. Never had a conversation with her, never sat down, never really interacted via email either. Well, why do you think you need an accommodation? Well, what could possibly be done? And no, that's an undue hardship. So I lecture about that because that's a big deal to go to the Supreme Court. So what happened was, to finish the story, the Supreme Court denied the petition for cert. So they didn't hear it. They didn't hear the issue. They decided, you know what, that's not important enough for us to get into. We have enough with all the other stuff on our plates right now. So the exemption based on a religious belief, you're also required to do that. But if it's an undue hardship, you don't have to accommodate that. It's easier to meet the undue hardship than it is to have to accommodate someone for ADA. It's the undue hardship with religion if it imposes more than just a de minimis cost or burden on the employer. So if it's more than anything than just an incidental burden on you, you can require that someone get the shot regardless of their religious beliefs. So can they ask, can you tell everybody that the whole workforce is vaccinated? Yeah, maybe that'll help too. I think so. You don't want to say, well, Joe's going to wait on you today because he's vaccinated, and Max isn't, so we're not going to have him waiting tables. They just don't tell coworkers, don't tell the public, of course. That's all privately held, closely held information. It's better if HR handles that. If it's a smaller organization, they just have upper management handle that. Any written information on it has to go in this separate medical file. It's separate from the personnel file, the separate location. That's just like anything regarding FMLA or disabilities, ADA, any of that, all goes in the medical file. So the testing results go there, vaccination stuff goes there, diagnoses, doctor's notes, quarantine orders, all of that goes in that other folder. So how about incentivizations? Can employers incentivize them? This is another instance in which the EEOC has been supremely unhelpful. Recently, they announced that it was withdrawing 2 proposed rules regarding whether employers can incentivize employees for doing wellness programs, participating in wellness programs like working out, meditation, yoga, that sort of thing, nutritional coaching, that sort of thing. And the guidance was originally proposed in that context, but now it's obviously the case that a wellness program would include vaccination. Can you incentivize people to vaccinate so that, within within the realms of the law. And so it withdrew the guidance. The former guidance had said, you cannot incentivize someone to do something like get a vaccine by more than giving them, you know, a $5 gift card or a water bottle kind of thing, because you may be discriminating against people with disabilities, again, who can't get the vaccine, or people with, you know, with genetic disorders. That's the Genetic Information Non-Discrimination Act I've referred to on the slide. People like that who can't get it for some kind of genetic disorder. So, you know, you're handing everybody, you know, a $500 bonus or something, yet, you know, and these people are saying, well, you know, you're not giving me anything. I mean, so question mark number one, whether people are going to sue the company over $500, right? Or over a few hours off to get the vaccine, paid hours off, or unpaid hours off. Is anyone really going to sue over that? You know, I find that unlikely. So, you know, while I'm not saying you must incentivize people, or like it's a great idea to incentivize people, I don't have a problem with it legally, because I think your risk is really low if you do, that someone's going to sue you for not giving it to them. I don't think so. It's just that the proposed rules had said that you shouldn't do that, and it gives me a little pause. We just don't have any guidance though, because they withdrew the rule. Does that mean that they don't think it's a good rule as applied to vaccines? I don't know. But, you know, in a minute, I'm going to talk briefly about the ways to offer incentives, and then I'll move on from that to talk a little bit more about how you can incentivize. So they've done it. People have done it. Lots of clients have done it. Paid time off, cash payments, unpaid time off. So one recommended way to go around this and to seem like the compassionate employer is to give whatever incentive you give to some people, forgetting it to other people. You know, the problem then is that how are you incentivizing anybody if you're going to give the same thing to someone else? This is a suggestion I heard from someone else, and I thought, well, you know, I'll throw it out there. They have to do something to receive the incentive, you know, the $100 or the 2 hours off or whatever it is, like watch a safety video, you know, attend a class, something like that. But, you know, which might be worthwhile if you're going to, if you want to make sure your workforce is really well educated. Okay. But, you know, the other way to incentivize people is to set up a work sponsored event to make sure that it's really easy to get vaccinated, which is never a bad idea. But in conjunction with this, I would just say, decide on your approach, add a vaccination policy, include that they can request and receive their available accommodations if needed. Explanation maybe of payments for the time to receive vaccinations. Decide on your incentives and just tell them what they are. Clarify the use of PPE by vaccinated employees. Clarify if things are going to change if you're vaccinated or not. Okay, so sitting here in the state of Delaware at this moment, we still have a public mask mandate. Our state's governor has said, even if you're inside in an office building with other people, because it's a public place, you have to wear a mask. There's no exception in our rule or in a lot of other governors' rules to for people who are vaccinated. So, you know, does it really change their working conditions? If it does, then tell them how it's going to be affected. You know, if you're in Florida, hey, you don't have a statewide mask mandate. Maybe you can say, hey, here's an incentive for you. If you don't do this, and everyone in your pod does this, then hey, you don't have to wear a mask if everyone gets vaccinated. That's a nice incentive. And then, you know, your policy could say have updated protocol about, as we learn more about people who are vaccinated and their ability to infect other people. So this is really what I was talking about at this point. Keep limiting the contact, keep using face coverings, get them to receive permission or advance notice that they're working in the office, do the symptoms checklist, all this stuff, you know, encourage calling out, sanitization, etc. So getting to that, when's it safe to return to the office? So in case number one, when a worker is in contact with a positive or suspected positive person, they can test on day number 5 following the exposure. And if they're negative, they can return on day number 8. If they're positive, if they have no symptoms, right? If nothing's come up. If they're positive on day 10, they can come back if there weren't any symptoms, or if the symptoms have resolved pursuant to the definition by the CDC, which is on the slide. Case 2, vaccinated worker was in contact with a positive or suspected positive person. No quarantine. No quarantine is required. No test needed. No labor gap. Come back to work. You're not missing any time, which is great. So vaccinations are good for business as well as for people's health. In my view, as an employment attorney, I see how that can be really helpful with your workforce. So the American Rescue Plan Act is going to cover another way to incentivize. Now, under the American Rescue Plan Act, your company can pay, if you are 500 or less employee company, your company can pay people sick leave pay for a number of things, including getting the vaccine and recovering from the vaccine. Now, it expands the reasons to take leave to include those, and also to include seeking a test, waiting for test results, and adverse reactions to the vaccine and recovering from whatever happened as side effects. So this provides an additional yearly allotment of up to 80 hours, or 10 days, 2 weeks per employee of qualifying paid sick leave. And that's going to be available for 2021 tax credits through September 30, 2021. Maybe this will be extended. We're not sure. Depends what happens with the pandemic. Obviously, I hope they don't have to extend it. But that we're now looking at, under the Families First Coronavirus Response Act, we were able to give paid sick leave, had to give paid sick leave, right, if we were under 500 employees, and we're able to get the tax credit. This is the way. You're not compelled to do it, but if you do it, then you can take the tax credit. So it's based on employees' full pay, cap of $511 a day. If related to one of the old sick reasons, to watch others, to quarantine, I'm sorry, not to watch others, to quarantine yourself, to recover yourself. And then now it's get a vaccine, get a test, waiting on those recovering. Okay, so that's full pay. And they get 2/3 pay if they're watching other people, if they're taking care of others, watching them when they're quarantining. Also, you can pay people for family leave, again, just as they did before, but now there's 12 weeks full pay available. 12 full weeks of 2/3 pay available. And if you don't understand that, I don't blame you. The available tax credit per employee is 2/3 the employee's regular rate of pay. And now you can do it for 12 weeks and take the tax credit off your employer's side payroll taxes to get that paid for. It's nothing out of your pocket. So that's a real advantage. That's a good thing to have. So, here we are at our question and answer segment, and I'm actually going to stop sharing my screen in a second. But, here's my information. And I'm sure that if you contact Wire Association, the New England chapter, they can give you my information as well. If anything interested you in the presentation, you want more information, you want any of the guidance on policies or anything, feel free to reach out to me. Also, if you want to connect with me on LinkedIn, I do post a lot of stuff about employment law. LinkedIn recently told me that in 2020, I posted 62 times. So that's blogging or posting something meaningful. I don't do like, hey, yeah, me too. I don't do those. So if you want to link in with me, follow me, then you'll get a lot of interesting insights and updates on what's going on with employment law. So I'm going to stop sharing my screen, and we're going to talk to you guys.
Great, thank you, Katherine. We had a couple people post questions in the chat. I'll ask this one here. We have employees that we are regularly reminding to wear PPE. We are doing write-ups as needed. However, are we liable to claims if that person is shown to have spread COVID?
Right. So again, that's your personal injury liability. It is definitely something that, again, the workers' compensation people have been fighting. The insurance companies don't want to pay that. To back all the way up, the person has to show that they got it at work, right? You have to prove that they got it at work. That's difficult. It's really got to be the case where I read a case recently where a guy said, I had an injured foot. And so, I'm sorry, not the guy, he passed away. His widow said he had an injured foot. He went nowhere but the doctor's office between this date and this date. He had no symptoms. Then he reported to work, having gone nowhere but the doctor's office one occasion and having no symptoms thereafter for weeks, right? Nothing. He'd gone nowhere. He reported to work. 6 people got sick out of an office of 11 because they were all crowded into one space. And she's suing. The widow's suing for, loss of consortium, wrongful death, pain, suffering, etc. So that person would have a better case than your average Joe. I really would think about, disciplining the person. Your policy should say that you can discipline the person if they don't follow your COVID rules. Just in case. You also just don't want everybody to get sick. Forget about getting sued, right? You don't want the business shut. You don't want the PR nightmare, and you don't want people getting sick.
Right. We had 2 questions related to about employer requirements for vaccination, which I think you addressed. One, maybe you'll understand it better than I do. What does the emergency authorization of vaccines mean on creating a company's vaccine mandate?
So emergency authorization, basically, you can mandate that people get a vaccine that has emergency authorization, which is our vaccines now, the ones everyone is getting, are all emergency authorization only. They're not final approval, right? But the answer to the question is you can mandate someone get those. They are considered available, and that has been sort of stated upfront that yes, you can mandate those for people who don't have disabilities or religious objections.
Okay. I have a question here. The optics of having the same exact COVID policy as last April doesn't translate very well to salespeople. I know at the beginning of this, I encourage people to offer up possibly their facilities for company tours for a next education event, probably next year, but can we update, loosen the policy at all at this point?
So again, I think as your state changes its policies and its regulations, then I think the prudent employer can say, hey, I'm going to watch what the state is doing, and I'm going to do what the state says I can do. I'm operating in Florida. For instance, I had a client that was talking to me about operations in Florida. Florida no longer has a statewide mask mandate. And my employer client was wondering whether they could give an employer-sponsored event and under what circumstances that would be a good idea versus a bad idea. And so we talked it through, and I said, well, look, there's certain municipalities in Florida that still say you have to wear face covering. And they said, yeah, that's true, like Miami. So there's not a statewide face covering mandate, but there's a municipality problem with some of them in Florida. So don't have it in the municipalities without face coverings. That's not a good idea. That's inviting trouble. You say you're inviting these clients and they get sick. I mean, that's not a good idea. Of course, we don't want them to get sick. We also don't want them to sue you for attending your client's, your company sponsored event. And there's a couple of things to look at, and whether it's company sponsored, by the way, it's, basically who are you inviting? How much control do you have over who you're inviting? And basically, I had this question, is it a company sponsored event if the manager says, hey, everybody come to my house and we're all going to have a barbecue? And I said, well, it kind of depends on the influence that the manager has over these people, and do they feel coerced and stuff like that. But it boiled down to, with the Florida question, was like, Florida still said no gatherings of more than 10 people. So it was, okay, have a gathering, no mass with 10 people. And to be safe, if you want to be even safer, do it outside, right? If they're all vaccinated, then that should be perfectly safe according to CDC. But yeah, we can start loosening up a little bit, but follow your state, and we'll see what OSHA says.
Okay. We just had this question. If you have an employee or employees that test positive more than once, are companies liable to pay them each time that they have to take time off? You know, if you pay them while they're off the first time, do you have to pay for the second and or third time?
Gotcha. This was a problem when we had a mandatory feeling on it, right? When there was a law that dictated, the Families First Coronavirus Response Act dictated that you paid people up to 80 hours. Now, we don't even have a law that mandates that anymore. There is no mandated sick leave at all, paid sick leave. If you want to pay them for up to 80 hours, you can take the tax credit. If you pay them for more than 80 hours, you're not going to get the tax credit. You have to do it exactly as it was done under the FFCRA, or else you won't get the tax credit. So if you want to be the generous employer that gives additional, additional leave, if I understood the question correctly, it was the person tested positive twice. Or, maybe we mean that, they tested positive and then their family member tested positive and they have to watch them, et cetera, because they're a little kid or, whatever. That's a situation where it would apply.
Okay. Yeah, I think the question may have meant like they tested positive and then the subsequent time, maybe they had exposure.
Yeah, okay, exactly. Well, so the answer is the same. It's 80 hours, you can take tax credit. After that, if you want to be generous, you want to say, okay, you can take all your PTO in a row. Okay, I'm going to give you unpaid leave. That's really your discretion. You don't have to give any leave at this point at all. But you have to think about employee morale, people leaving. I know people are having a hard time with workforce now, even just keeping boots on the ground and people in the plants. So think about that too.
Mm-hmm. Would you recommend having customers events for customers at this time, hosting events for customers?
I think so. I think it's okay as long as you are following your state's guidelines. And I mean, the very best practice would be to have them outside, because all the data now is showing that only 10% of cases are contracted outside versus 90% inside. You also could quiz people. You could say, if you're vaccinated, you're welcome to come to our event, but what are you going to do? Card at the door? It's so funny. Everyone gets these cards now, right? The immunization card. And it's sort of, are we going to have to use that for admission to the movies? Are we going to do it for company events? We're just going to have to trust people's good judgment. And therefore, you're letting go a little bit, right? I like the outside option, especially as the weather's getting nicer. Why not have it outside?
Okay, great. Well, thank you very much. I think I'm going to pass it back to John. Get your time in answering all the questions.
Yeah,
oh, you're welcome.
Yeah, thank you. Thank you. It does look like we're out of time. However, the presentation will be available to everybody who registered. And I don't think there were any unanswered questions, but if you think of any other questions, follow up, please feel free to contact Katherine. And I'd like to take this last opportunity to thank our presenter, Katherine Fry. Thank you, Katherine. And also Jonathan Roof and Lori Parent from the Education Committee, the WAI staff who helped put this together, and all who listened today. Thanks very much. Bye-bye.